On your cases, those being 1074-0152-5507,
Yes,
he
Judge.
is waiving. Is that correct?
Yes, Judge. Waiving up to seek drug court.
Pardon?
Waiving up to seek drug court. Yes, Judge.
All right. Mr. Smith, state your name.
Stephen Lawrence Smith.
And on those three cases,
Before we even hear the first formal words in this courtroom, it's important to understand what kind of day this is shaping up to be. This is not a dramatic jury trial yet. This is a preliminary examination, a crucial legal checkpoint where the prosecution doesn't need to prove guilt beyond a reasonable doubt, only that there is probable cause to move the case forward. That lower standard matters because it explains why certain arguments succeed here even if they might fail later at trial. We're dealing with multiple felony counts, multiple cases being merged procedurally, and a defendant who is already navigating serious legal exposure before a circuit court ever hears the case. Waiving a preliminary exam, as we're about to see, is a strategic decision, sometimes used to avoid locking in testimony early, and sometimes because the defense knows the bindover is inevitable. As this unfolds, pay close attention to what is proven versus what is merely assumed. Watch how officer testimony is framed, how defense counsel attacks legality rather than facts, and how Judge Simpson controls the courtroom tone. And here's a question to keep in mind from the start. If you were facing multiple felonies, would you fight every step or conserve your battles for later?
the court's understanding is you're waiving your right to a preliminary examination. Is that correct?
Yes, Your Honor.
You understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you will not have that hearing and on these three cases, and that you'll proceed to circuit court for further resolution.
Yes, sir.
On those three matters, people also waive their right.
The people do, Your Honor.
Preliminary examination having been waived, defendant is bound over on the one count in case ending in 0152, on one count with two following in the case ending in 1074, and is bound over to circuit court on the four counts as contained in the other matter, the case ending in 5507.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. Pre-trial in these matters will be set for July 29, 2025, 1:30, Judge Cohn.
Thank you very much, Judge.
Bound on those matters. As to his other matter, are we ready to proceed to prelim?
We are ready, Your Honor.
Oh, yes, people are ready as well, I'm sorry.
They call you first witness.
Thank you, Your Honor. The people will call Officer Michael Stanky to the stand, please.
Here's where the real substance begins. Once Officer Michael Staney is sworn in, the case pivots from paperwork to narrative. Everything from this point forward depends on credibility, what the officer claims to have seen, why he acted, and whether those actions were legally justified. Prosecutors always start with background questions for a reason. Establishing experience builds trust before controversial decisions come up later. Notice how wide-ranging the officer's caseload is described to be: drugs, violence, theft. That framing subtly positions him as seasoned and reliable. But defense attorneys listen for something else: assumptions. When an officer testifies about beliefs, what he thought was happening, that's fertile ground for cross-examination. As we move into the welfare check narrative, now to ask yourself, at what point does a medical concern turn into a criminal investigation? That question will sit at the heart of this case.
Sir, please come forward and be sworn.
Officer Michael Stanky, first name C-H, last name S-T-A-N-A-D-Y.
You may inquire.
Thank you, Your Honor, and thank you so much, Officer, for coming today. I first want to start with just some background questions. How are you employed? How long have you been there?
Approximately a year.
What kind of cases do you handle?
Wide range, drugs, violence, assaults, thefts.
Okay, so I want to get a little more specific now and turning your attention to August 17th of 2024. Do you recall responding to an incident on that day? And what area was that?
It's on the east side of Ann Arbor, Arizona Drive, Arizona.
Okay. Now, without getting into what anyone said, can you just generally describe what the reason was for you going to that location?
Sure. I believe the dispatch call was welfare check on a man who was slumped over a moped seat on.
Okay. So did you in fact respond to that location yourself? Okay. Were you alone or with a partner?
Also,
Okay. What did you find when you got there?
I found a man sitting on a moped, which was perpendicular to the road, stopped. He was slumped over the front. I exited my patrol vehicle and approached him.
Okay. And as you approached, did you get any response from him?
Not initially. I walked to the front of the moped. He was drooling heavily over the handlebars, and then said something to hi, how are you?
And what happened?
And I believe he gave a verbal response of good, you, something like that.
Okay. And now you said he was slumped over a moped. What did this moped look like to you? What was there? Was there anything about it that struck you?
It was red. The kickstands weren't up, which struck me. Both his feet planted on the ground,
Okay.
swinging over it. That passing on the back, I believe.
Okay. And as far as you, why did you mention that the kickstands you said were not up? Were up?
I found it very unusual that him being slumped over, that he was maintaining his balance with both his feet planted on the ground.
Okay. I see. So did he take any action with that vehicle at any point in time?
He raised his body up, looked at me, then began to slowly back away, and verbal command, stop moving away from me. He continued to move away, and then he got off the moped and started running.
Flight changes everything, at least from the prosecution's perspective. The moment the defendant runs, the narrative shifts from welfare check to active investigation. Prosecutors will argue that running from a lawful command constitutes resisting and obstructing. Defense will argue that the command itself wasn't lawful to begin with. This is where constitutional law becomes practical reality. A person's decision to flee may look suspicious, but suspicion alone doesn't always equal legality. The question becomes, did the officer have the legal authority to order him to stay put? Notice the officer's phrasing: verbal commands, identification as police, repeated attempts to stop him. These details are crucial later when Judge Simpson evaluates whether the command was lawful. Think about it. If you panic and run during a police encounter that began as a welfare check, should that alone turn the encounter into a felony?
Okay. Now, I understand you just said that he started running, but I want to back up just a bit from the point where you said he slumped over to starting to respond to you. Why did you need him to respond to you? What reason did you have for continuing to interact with him?
Well, I believe he was one of two things, either suffering for a medical emergency or some sort of drug or alcohol necessitating an investigation.
Okay. So what did you do after, as you stated, he began to run away?
I laid the moped on the ground and then I gave chase.
Okay. How were you dressed at this time?
Full patrol uniform.
Okay. So when you say you gave chase, is that on foot?
Yes, ma'am.
Okay. And what happened after that?
He ran for approximately 40, 50 yards or so and then tripped. I was able to catch up to him where I tackled him to the ground and then was able to get him the handcuffs.
To be clear, I understand you're chasing him. Are you saying anything or asking him to do anything?
Yes, I believe I yelled at him to stop and I then stop, police, and he kept running.
Okay. And so at the point where he fell, what happened then?
I believe he fell on his stomach and I was on his back. I then was able to bring his hands behind his back where I placed the handcuffs.
Once handcuffs are on, constitutional protections tighten even further. Arrest triggers specific rules, particularly around searches. The officer states he performed a brief search and located a knife. Importantly, it's acknowledged as not illegal. That matters because the presence of a lawful object cannot retroactively justify an arrest. What does matter is the officer's stated basis for arrest: resisting and obstructing. Everything that follows, including searching the bag on the moped, must tie back to that arrest. This is where defense attorneys start building suppression arguments. Was the arrest lawful? Was the search truly incident to arrest? Or was it exploratory? Audience question: do you think running from police should automatically allow officers to search nearby property, even if it's no longer within reach?
Okay. And after you placed him in cuffs, what happened then?
I briefly searched his pockets, I believe. I located a knife, some other personal items. I brought it back to my vehicle.
Okay. And I'm sorry, pardon me. Now, you originally said that you were concerned that he might be under the influence. Is there any other reason that you were concerned about him being under the influence in terms of that moped?
Oh, that he was operating it while under the influence?
Okay, what makes you think he was operating it?
Both his feet kind of on the ground, like as I said, so it wasn't, you could say it wasn't parked kickstand up where it'd be immobile. So kickstand was down.
Okay. And was there anything, you said that you recovered a knife and you said personal items?
Yes.
Was there anything else that you took from him or found related to the moped itself? Any other items?
Those are the items that I found as a person. After placing them in my vehicle, I went back to the moped. I found a black bag, which I believe had been in the basket on the back of the moped. I looked inside that bag and I found numerous drugs, both illegal and prescription.
Okay. Now, at the point where you went to this bag that was on the moped, that is after that is after this individual was placed in the handcuffs, correct?
Yes.
So was he under arrest at that point?
Yes.
Okay. So what reason did you have for looking into what the bag had in it?
I believe we were taking him to jail.
Okay.
Incident to arrest.
Okay. You said incident to arrest. What incident to arrest?
I placed him under arrest for resisting, obstructing, or fleeing from me on foot.
Okay.
And then I believe you would be taking him to jail on that charge.
The phrase search incident to arrest gets repeated a lot in courtrooms, but it's not magic words. It's a legal doctrine with strict boundaries. Searches incident to arrest are meant to protect officer safety and prevent destruction of evidence, not to open the door to unlimited searches. Here, the officer admits the defendant was already handcuffed and secured when the bag on the moped was searched. That fact will matter later when defense invokes Arizona versus Gant, a U.S. Supreme Court case limiting vehicle searches once a suspect cannot access the area searched. This moment plants the seed for a future suppression motion. If the bag search is ruled unlawful later, the drug evidence could disappear entirely, regardless of what was found. Yeah, this raises a key viewer question. Should evidence found during a questionable search still count if it reveals serious crimes?
Okay, you just said incident to arrest. Are you saying that you searched him incident to arrest?
Yes, ma'am.
I just wanted to be clear about that. Okay, understood. Now back to that moped. What did you find in the bag?
Numerous narcotics. Without referring to my report, I believe there was substances which appear to be methamphetamine, cocaine, heroin.
Okay.
Pills.
First of all, can you describe why you suspected these substances to be drugs? I understand you said pills. I'll get to that in a second. But what format were these things in? How did you find them? Were they packaged? What exactly were you looking at?
Sure. I believe one of the first things I opened was a container, which may have been some sort of representing some sort of skincare or hair product. Inside of that were several large shards, which I identified from my experience being methamphetamine. There were several little glass jars unlabeled, which contained white powdery substances, which, based on my experience, is cocaine, and then the pills.
Okay. Now you say pills. What sort of container were the pills in?
I do not recall.
Okay.
But, exactly. I have vague recollections of unmarked prescription bottles.
Oh, as in a prescription bottle that did not have a label when you say unmarked?
Correct.
Okay.
Like I said,
Okay. I got you. Okay. So now I understand you suspected that these were certain substances. How did you go about verifying that?
I use an online database called Pill ID. I just run the shape, color, and markings on the pills, and then it will return the results.
Okay. And just generally, I know you've named quite a few different things you suspected, but what kind of amounts did you recover in terms of these substances? In your training and experience, how did those amounts appear to you?
The amounts appear to be far greater than what one would have for personal use.
This is opinion testimony, and that's important. Officers are allowed to give opinions based on training, but those opinions must still be supported by facts. The defense will later hammer the lack of precise measurements for many substances. Without clear weights, greater than personal use becomes subjective. This is where probable cause survives, but proof may struggle later. At a preliminary exam, the bar is low. At trial, jurors demand specifics. Watch how the prosecution stacks circumstantial indicators: quantity, packaging, scale, multiple substances. Each alone might be weak. Together, they form a narrative. Viewer question: would you convict someone of intent to distribute based mostly on inference, or would you need hard numbers and direct evidence?
Okay. And so, in addition to the substances that you suspected to be narcotics at this point, are there any other items that you found of interest?
I believe that he had some drug paraphernalia on it to include needles, aluminum foil, maybe a pipe or two.
Okay. And, okay, now again, so going back, in terms of verifying what those substances actually were, what process did you follow?
I logged them into our police property room. From there, the detective is supposed to submit them for testing.
And did you get results back?
I believe we did.
Okay. Now, I'm sorry, I'm sorry, I'm jumping around a bit. I have to kind of go back and forth. So you submitted the substances that you found in the bag to the lab.
Yes, so
Okay, but you started out also by saying that you suspected that this individual was potentially operating under the influence. What did you do to follow up on that concern?
I called HVA and paramedics come evaluate him after he continued to appear to be unresponsive or under the influence of some sort of narcotic.
Okay, and what happened after that point?
HVA paramedics were on the scene. They loaded him onto a stretcher. I believe they stated that.
Objection, hearsay.
Understood. Officer, remember that you can testify as to what you directly observed. And if the defendant in this case happens to say something, you can always testify to what he said. But aside from that, I have to have you limit your answers to what you personally observed, not what somebody else said, okay?
Judge Simpson steps in here to enforce evidentiary boundaries. And this is a subtle but powerful moment. Judges act as gatekeepers, preventing hearsay from contaminating the record. Even at a preliminary exam, rules still matter. By limiting testimony to personal observations, the judge preserves fairness while still allowing the case to move forward. This balance is a hallmark of experienced jurists. It also signals to both sides that while the court will allow probable cause arguments, it will not tolerate sloppy lawyering. This intervention strengthens the credibility of the process itself, something appellate courts look for later. As we move deeper into cross-examination next, ask yourself, is this case built on solid constitutional ground or just enough to survive for now?
So again, you can describe what happened. You said HVA loaded him into a stretcher. And what happened after that in terms of following up on the operating concerns?
I don't recall any further steps I took on that front.
Okay. So just to be clear, did you receive results back from what you submitted to the lab?
I believe so, but I don't have that information.
Okay. Oh, understood. I just wanted to know, but you recall getting results back? Okay. And you mentioned that these amounts you stated were far greater than what you would expect to see for personal use, correct?
Yes.
Okay. So I want to follow up a bit on back to this moped situation. So you've described how it appeared, some unusual things about this individual's appearance with it. Was there any other information you got about the moped itself?
Yes, we ran the started that it was stolen.
Okay. And did you have any information on who the individual was that the vehicle would belong to?
Yes, I believe his name was Christopher.
Okay. So is that information, as far as you can see, when you look into lien, is that the registered owner or who's it?
I believe he was the registered owner.
Okay, understood. Now, what information did you get in terms of who this individual was who was actually on the moped on this day?
He identified himself as Stephen Smith. They were able to find a driver's license and were able to match his photo to his image before him.
Okay, so did you ask him his name directly?
I believe I did sometimes without success, and then other officers attempted to, and then they were able to get his name.
Okay. So did you take his name and do a search, or how did you connect that with anything else?
I did. I ended up the name Stephen Smith in Courtroom and started a driver's license. With a
Okay.
photo match.
Okay, so the image that you came up with in your system matched the person that was before you
Yes.
at that time. I see. And as far as you know, no one by the name of Stephen Smith had any affiliation with that vehicle.
Not that I'm aware.
Okay. Do you recall, I'm sorry, I apologize if I asked you this already, what substances those lab results showed when they came back?
Only vaguely from looking at the report earlier this morning that I believe certain substances came back testing positive for methamphetamine and cocaine.
Okay. Your Honor, the people are approaching counsel first. Exhibit. Your Honor, unfortunately, the people tried several times to print this exhibit out in hard copy for the court. Unfortunately, the
What
printer
exhibit?
refused to do so. Can I display it on the screen?
What exhibit?
People's proposed exhibit number 1,
Which is?
the lab report from Michigan State Police.
I'll just state that although I did file a lab objection, I'll waive
Yes,
that
you did.
objection for purposes of preliminary exam.
Thank you. All right.
Officer, can you tell me what you're looking at here?
It appears to be a lab report from Michigan State Police.
I can scroll up a bit. Okay, thank you. And is this consistent with the report that you recall receiving in this case?
Yes.
Okay, and just to be very clear, this is from the substances you recovered from the backpack on the moped.
Yes.
Okay. These results are consistent with what you recall.
Yes.
Given that the people would move to admit people's proposed exhibit number 1, which is this laboratory report from Michigan State Police.
This is a pivotal evidentiary moment. The lab report is where suspicion becomes science. Until now, everything rested on officer perception and experience. Once the Michigan State Police laboratory report is admitted, the prosecution gains objective confirmation that at least some substances were, in fact, illegal drugs. But notice something important. Defense counsel explicitly waives objection for purposes of preliminary examination only. That's not generosity, it's strategy. By allowing the exhibit in now, the defense avoids appearing obstructionist while preserving the right to challenge admissibility later at trial. Also pay attention to what the lab confirms and what it doesn't. Not every suspected substance is clearly verified, and that gap will matter when intent to deliver charges are evaluated. At this stage, probable cause is enough. Later, proof beyond a reasonable doubt is required. Audience question: if lab results confirm drugs but leave some uncertainty, should all related charges still move forward?
Any objection or what here?
No objection for purposes of preliminary exam.
Exhibit 1 is admitted.
Thank you very much. So you described the individual that you saw and the steps that you took to identify him. One of my last questions is that individual in the courtroom today, sir?
Yes.
And can you please just describe him based on what he's wearing and where he's sitting?
Sitting at the defendant's table wearing a white t-shirt.
Thank you. Your Honor, may that record please reflect that the witness identified the defendant.
That objection record shall so reflect.
Thank you very much. And just to ensure one more detail from very early in the questioning. So you mentioned that this incident took place on, I think, Fairlane and Provincial. What area is that in terms of city and county police?
That's sitting in our county, Washington.
Okay, thank you very much. I don't have any further questions at this time.
Cross-examination.
Thank you, Your Honor.
Good morning, officer. If you don't hear one of my questions, let me know. I'm going to try to move through this relatively quickly. The first thing I want to ask you before I forget, you came up with information that the moped was stolen, correct? But you did not get any sort of admission or confession from Mr. Smith that he was aware that the moped was stolen. Isn't that correct?
Correct.
Did you gather any other evidence in your investigation to show that Mr. Smith knew the moped was stolen?
No.
Okay. Now, you first testified your reason for being in the area where Mr. Smith was. Dispatch called out for a welfare check, right? Did you get any information about what anyone who may have called 911 or dispatch provided in terms of why a wellness check was being requested?
I believe they used the phrasing slumped over. I believe they had tried to give him a drink and he seemed slow, lethargic, and they just wanted him checked out.
Okay. So you had no reason to believe when you first appeared on scene with Mr. Smith on the moped that he was involved in any kind of criminal activity, correct?
This is one of the defense's strongest lines of questioning so far. By locking the officer into admitting there was no initial criminal suspicion, defense counsel is laying groundwork for a constitutional argument: unlawful detention. The defense systematically strips away justifications. No observed driving, no running engine, no traffic, no complaints of criminal behavior. Everything circles back to one point. This started as a welfare check. This matters because police authority expands or contracts based on context. A traffic stop allows certain actions. A welfare check allows fewer. Defense counsel is trying to freeze the moment in time before the run, before everything escalated. Audience engagement. Should police be allowed to detain someone indefinitely during a welfare check just to make sure? Or does that cross a line?
I wouldn't necessarily say that.
Okay. Thought maybe he could be under the influence, but you never saw him drive the moped, right? You did not see him operate the moped even once you arrived at the side of the roadway, correct? The moped was not running when you made contact with him?
Correct.
It never turned on while he was on the moped? And other than moving back a few steps when you first made contact with him, verbal contact, when he's walking back on the moped, you never saw the moped move otherwise, correct?
Yes.
Nor did you get any information that somebody had seen him driving the moped around the neighborhood, right? When you are setting out to do a wellness check, what are you looking for?
The physical condition of the person I was called.
Okay. Are you, when you made initial contact with Mr. Smith, did you notice any weapons on him? You noticed a pocket knife after you tackled him in his pocket, but that wasn't an illegal knife, was it?
No.
Okay. When you're speaking to Mr. Smith, your testimony was something to the effect that either you or he said, "Hi, how are you? Fine, good," something like that. What do you remember about him actually saying to you?
I approached him, I asked him how I believe, and he legit said it was very normal. I believe he tried to say, "Good, you," as in, "How are you?"
Okay, but he did say good.
Good.
Did you have any reason to believe that he was a danger to other people in the area at that time?
Based on his faith.
Did you believe he, at that point in time, was a danger to himself in the immediate sense of the term? That he could do something to harm himself while you're next to him?
No, not besides being under the influence of a drug and being medical attention.
Okay.
This exchange quietly undermines the prosecution's alternative justification: emergency intervention. If the officer believed the defendant was neither a danger to himself nor others, the legal basis for detention narrows even further. Defense counsel is boxing the officer in. No criminal suspicion, no imminent danger, no visible weapons, no drugs in plain view. That combination is powerful when arguing unlawful seizure. From a legal standpoint, this is where the defense starts building a suppression motion in real time. Even if the judge binds the case over, these admissions will be replayed later, possibly in front of a different judge, with higher scrutiny. Viewer question: if police say you're not dangerous and not committing a crime, should they still be able to stop you from leaving?
And sometime shortly after you make contact with him, he gets off the moped and begins to run. Is that correct? Okay. You had a body cam operational at that time, is that correct?
I did.
And have you viewed that to just verify it is what you remember seeing that day? And that's been provided to the prosecutor's office, as far as you know? Okay. This is defense proposed exhibit A. I would seek admission of this and just want to ask the officer to view a few moments and then follow up questions. Any objection?
Do you have a specific time?
Just starting at the beginning, the body cam, approximately maybe 30, 40 seconds.
Okay. Okay.
Seek admission of exhibit A.
Objection.
No objection.
Exhibit A is admitted.
Thank you, Your Honor. I plugged in and we'll press go once we're up. Officer, is this you getting out of your vehicle?
Yes,
And this is the area that you made initial contact with Mr. Smith?
it is.
That looks like a neighborhood,
It is.
pretty large yards. Doesn't look like there's any traffic around at the time.
Not mine, too.
Okay.
Yeah, whoa, whoa, no, no, oh, no, stop moving. Up, whoa, hang on. Everyone got one run from it. Stop, please. And then, well, sorry, stop. Stop, here.
All right, I'm going to stop it there, officer. Is it fair to say that in that short time frame you're talking to Mr. Smith, when he's on the moped, that you did not observe? Let me ask it this way. Did you smell any alcohol on his breath? Did you see any drugs or drug paraphernalia on his person? Did you see any drugs or alcohol bottles, what have you, in the basket of the moped?
No.
This sequence is devastating for the prosecution's initial justification. Defense counsel systematically eliminates every sensory indicator typically used to support intoxication claims. No smell, no visible substances, no paraphernalia in plain view. What's left is behavior, and behavior alone is slippery ground. Medical conditions, exhaustion, neurological issues, and panic can all mimic impairment. The officer even concedes he is not a medical professional. At this stage, the defense isn't trying to win outright. They're creating doubt. Enough doubt to argue that the encounter escalated without lawful foundation. That's all they need for suppression later. Viewer question: should odd behavior alone ever justify arrest-level police action?
Did you have any actual evidence other than your suspicion that he might have had a medical or under the influence of something, like you said before? Do you have any other evidence that would lead you to believe he actually had consumed alcohol or drugs?
I believe his behavior was evidence that he's.
Okay. Have you ever dealt with people that have seizures?
Yeah.
Could it have been that his appearance was that of a person having a seizure of some sort?
No, not a professional. I didn't testify.
Okay. So until HVA showed up, you would not be able to determine whether he actually could have been involved in a medical emergency. Same thing if he had low blood sugar. Are you familiar with diabetes? People that have low blood sugar, really low, can look like they're under the influence. But you had no information one way or the other whether or not this actually could have been some medical situation for Mr. Smith, right?
Right.
And that's why you, in fact, called HVA later, once you had him under arrest in the back of your patrol car, so they could check him out, correct? And ultimately, he was not arrested and taken back to the police station. He was taken to the, U of M hospital. So you didn't actually book him in order to inventory his property, right?
Not ultimately. No, I'm not booked him to inventory his property.
Not even after he went to the hospital.
Book him, no.
Yes. Okay. So in other words, you didn't have any of his property. If somebody is arrested and booked, then you inventory their property to make sure you have everything checked off, right?
No.
You don't do that when
No.
somebody's arrested?
And booked? No, not the and booked. No, just arrested? Yes.
Okay. You, at the time, you told us earlier in your testimony that you arrested Mr. Smith for resisting you as a police officer, correct?
Correct.
But isn't it fair to say that you can't arrest someone for refusing to get medical assistance?
he prevented me from conducting an investigation into whether he was needing medical assistance or under the influence of drugs, Ralph.
Okay, but if you see a gentleman who begins to walk away and then run, doesn't that tell you that he seems to be fine?
No, I would not say it seems fine.
Okay,
He tripped after a short distance.
but he wasn't asking for your help, was he?
What's the point of this question?
This is a tense courtroom moment, and Judge Simpson allows it to continue. The defense is probing motive and legality, and the judge recognizes its relevance. This exchange highlights the delicate balance judges must maintain, allowing robust defense without letting proceedings spiral. Judge Simpson's response shows confidence and command. He understands where the defense is going and lets them build the record. From a viewer's perspective, this is a reminder that judges aren't passive referees. They actively shape how arguments unfold, especially when constitutional issues are at stake. Think about it. Should judges step in more often to clarify the stakes for the audience, or stay strictly neutral like this?
To understand why he arrested Mr. Smith the way that he did. Just a handful more questions, Your Honor. So you arrest Mr. Smith, place him in the back of your patrol car, right? He did not resist you putting handcuffs on him, did he?
I don't believe I was recall to be holding him right on. I didn't at the time. But
Okay. And at no time prior to him being taken out by HVA did you conduct field sobriety tests?
I didn't.
Or even interact with him to see if he smelled like alcohol or something?
Are you going down a road that just indicates the officer's conducting an investigation? Because first of all, the moped is illegally placed where it is because it's in the roadway perpendicular to the roadway. That's number one. But are you attempting to ask questions go to whether or not the officer would have had the right to take that individual into custody or that they were resisting and obstructing?
Yes, Your Honor.
Go for it.
In situations, and again, I've asked you these questions, but you place Mr. Smith in the back of your patrol car. It sounds like you did not ask him any more questions or other than trying to get his name before he went off with HVA, correct? And when you searched his bag, which was near the moped, did you get his consent?
No.
Did you get a search warrant? Was it within his reaching distance once he's in the patrol car to get something out of it? And did you yourself have any reason to believe, strike that, from the outside of the bag, were you able to see anything that looked like controlled substance or paraphernalia or anything illegal?
No.
And unless somebody is a threat to himself or others, isn't it true you cannot take somebody in for a medical involuntary commitment unless they're a threat to themselves or others?
Sure.
And in this particular case, isn't it also true that you did not seek any sort of petition for him to be involuntarily committed, even after he was taken into custody and gone to the hospital?
What is the relevance of that?
Again, I think it goes to the legality of the arrest
You don't have.
and the search and seizure.
I get where you're trying to go. He doesn't have to answer that question.
All right, let me ask a few more questions about did you field test any of these controlled substances?
No.
The lab report that was People's Exhibit 1 shows 1.88 grams of a combination of methamphetamine, cocaine, xylazine. Do you know where that particular, those substances came from in terms of a container, where they were found?
No, the detective charged that.
Okay. Did you find any logbooks or notebooks showing sales of anything in Mr. Smith's bag or on his person? Did you ever see him selling drugs to anybody? Did you have prior contact with him selling drugs? Did you find any scales inside of the bag?
I believe so. I could reference my report.
Sure, yeah, if you want to reference your report just to be sure.
Yes, it was a small scale.
What kind of scale was it?
The scale is the prosecution's strongest circumstantial evidence for intent to distribute. Scales suggest weighing, packaging, selling, but context matters. The defense will argue alternative explanations, especially without sales records, large amounts of cash, or observed transactions. Notice how uncertain the testimony is. I believe so. That phrase appears repeatedly, and while it survives probable cause, it weakens certainty. At trial, that uncertainty becomes ammunition. This is the difference between surviving a case and winning a case. Audience engagement. Is possession of a scale enough to infer intent to sell? Or does that go too far?
Okay. Did you find any money inside the bag? Did you find money on his person? No further questions, Your Honor. Thank you.
Will you redirect?
Very briefly, Ron. Sir, very quickly, you mentioned in the beginning of your testimony that you were concerned that Mr. Smith could be operating under the influence. Is that accurate?
Yes,
Is that a crime as far as you know?
it is.
Okay. And just again, when you were fully uniformed, you asked him, he began running, you testified, and did not follow your commands when you asked him to stop, correct?
Correct.
Okay. You stated that you took him into custody, or handcuffed him rather. And what is the phrase you use about the search for the bag? What was the reason for it?
Incident to arrest.
Okay, can you just explain very quickly what that means?
Sure. Up until the point that HBA tells me that.
Why am I getting an explanation on search incident to arrest? I think I know what that is.
Your Honor, I know that you do. Unfortunately, I was trying to make it extremely brief. Counsel wanted to create a record. I just wanted to very quickly rebut it with about 2 lines.
Go ahead.
As I was saying, until the point that HBA arrives and tells me he should go to the hospital, not to jail, I conducted my investigation as if he was going to jail. I had no reason to believe that he was certainly going to go to the hospital. He was well enough to have run away from me, approximately 50 yards. So I fully believed that he was going to be going to jail that day. So I began to inventory his property.
Understood. Thank you so much, sir. And I think my final question is, when you spoke earlier to the amount of the drugs that you found, you mentioned that it was not for personal use, correct?
I did not believe it was.
Okay. And in your training and experience, what is having an amount of drugs similar to what you observed in this case consistent with, as far as you know?
Distribution of narcotics.
Okay. I don't have any further questions. Thank you.
Real quick, officer. The positioning of that moped in the street parallel to the curb, that's improperly parked if it were parked. Is that correct?
Sort of hard to say as it is. I believe a dirt road is not very well marked in that residential area, but I would.
Well, but it's parallel. It's
Yes.
parallel in the road. It's not going with the roadway, correct?
I believe you need to be parked.
Pardon?
I believe you need to be parked parallel to the roadway.
Okay, thank you. Any questions based upon the court's question?
Not from the people.
No,
Questions? You may step down. Thank you. Any additional witnesses?
Not from the people.
Any witnesses for the defense?
no, Your Honor.
You have a motion.
Your Honor, the people are going to move for bind over on counts 1 through. Let me rephrase it like this.
This is the prosecution's closing pitch at the preliminary stage. Notice the careful narrowing. 5 felony counts charged, but only 4 actively pursued for bind over. That concession is strategic. By abandoning the weakest count, the prosecution strengthens credibility on the remaining charges. At a preliminary exam, this isn't about proving guilt. It's about showing enough evidence to justify moving forward. The prosecutor walks methodically through identity, jurisdiction, officer credibility, flight, search, and lab confirmation. Each piece alone may be contestable, but together they form a probable cause mosaic. Judge Simpson is listening for one thing: whether factual disputes exist that a jury should resolve. If they do, bind over is appropriate. Audience question: should prosecutors be rewarded for narrowing cases early, or should all charges stand or fall together?
Mr. Smith is currently charged with 5 felony counts. The people are moving for bind over on 4 of those 5. I do recognize that there is some discrepancy with count 4, which is controlled substance possession of analogs. The results shown on People's Admitted Exhibit number 1 shows that there are markings for that particular substance. However, the detection of it suggested something different that could not be confirmed. I do not contest that those results are basically inconclusive for our purposes. So I am not fighting for count 4 to be bound over. However, I do believe we have met our burden, particularly at a probable cause standard, to bind over on counts number 1, which is controlled substance delivery, manufacture of cocaine less than 50 grams. Count 2, delivery, manufacture of methamphetamine less than 50 grams. Stolen property, receiving and concealing a motor vehicle, as well as police officer resisting and obstructing. Officer Stanky testified, I believe credibly and reliably so, that he's an officer with AAPD, Ann Arbor Police Department, that this incident took place within the city of Ann Arbor, County of Washtenaw, that he eventually identified the individual who was on this moped as Mr. Stephen Smith by him, number 1, responding to his own name and stating so, as well as him getting identification, matching him up in lean with that photo and identifying him here in court today. His reasons for stopping were obviously of a concern, given that he was passed out, slumped over the handlebars, as we saw in the video that counsel admitted, and that he clearly had a concern about him being under the influence, as well as potentially operating as well, but certainly being under the influence of some sort of substance at that time. Given that, as soon as he began to investigate that, as a fully uniformed officer, clearly performing his duties, I think that Mr. Smith immediately running away from him by itself meets the standard and the elements for resisting and obstructing, given that he did not follow those commands, knew that that was a police officer, and immediately ran away. In terms of what happened after that point, he did a search incident to arrest, as he mentioned, as he did plan to take him into a custody for the resisting and obstructing. That search included a bag on that moped, which held a large amount of substances suspected to be controlled substances, which were then proven to be so in terms of being cocaine and methamphetamine, as shown by People's Admitted Exhibit 1 for the Michigan State Police laboratory results. Finally, he ran a report on that moped that Mr. Smith was found on, saw that it showed up in lien as a vehicle that had indeed been reported stolen. And it was not obviously affiliated with Mr. Smith in any way. Given that, the people believe we have met our burden and we move for bind over on those 4 counts, counts 1, 2, 3, and 5, excluding count 4.
Response.
Your Honor, as far as count 3, receiving, concealing stolen property, been no testimony or evidence presented that Mr. Smith knew or had reason to believe or know that the vehicle, the moped.
But isn't that a factual question?
I think there has to be some probable cause. I don't think so. I think in a case like this, it may come up as stolen, but there has to be some evidence that Mr. Smith was aware of it at the very least. And there's nothing here presented in the testimony.
Defense counsel zeroes in on knowledge, a required element for receiving and concealing stolen property. It's not enough that the vehicle was stolen. The defendant must have known or had reason to know. This is a classic defense move. Isolate an element and show it's unsupported. No confession, no admission, no evidence of tampering, no proof of awareness. That creates a factual gap. But at the preliminary stage, gaps don't necessarily kill charges. If a reasonable inference can be drawn, judges often let juries decide. This is where defense arguments shift from dismiss now to fight later. Viewer engagement. Should someone be charged for possessing stolen property without proof they knew it was stolen?
Okay, go ahead.
I think more importantly, and I think that cuts to the heart of 2 different issues, is that under the resisting and obstructing police officer, one key element is that the officer gave the defendant a lawful command or was making a lawful arrest or otherwise performing a lawful act. I don't see how the law or the Constitution allows a police officer to turn what is a wellness check.
You need to give me some case law, because I'm not going to argue law by Fikowski. I sat there and watched your exhibit. Your exhibit clearly indicates the officers in the performance of his duty, tells him, hold on, hold on, hold on. It's grabbing the front of the bike. The officer is in the middle of the investigation and your client gets off the bike, takes off. So you show me a case that where that is not resisting and obstructing. I'd like to see it.
Your Honor, there's a case, the City of Troy versus Olinger, Michigan Supreme Court, 438 Mich 477. This is talking about using the community caretaker exception to enter a house. But this is essentially what a welfare check is. Community caretaker of a police officer. It's not going to investigate a crime.
It may have determined, Mr. Pifeski, you're jumping to conclusions. When the officer arrives there, he's not sure what he has. He's investigating a potential crime or some wellness. He doesn't know, as many officers don't. One of the things is, during the course of that initial part of that investigation, he tells your client to stay put. He doesn't. He takes off.
But
he gave him a lawful command and he didn't follow it.
But I think the question comes up as to what authority does a police officer have to detain someone on what initially starts as a medical check, a wellness check, if the observation of the individual is that he gets up and is able to move around.
He doesn't know that, though.
Unless he's a threat to somebody else.
You can argue that at trial. Go ahead with your argument.
Well,
because I'm going to tell you, you're just wrong.
For purposes of the record, I'm making that argument. I don't believe it's a lawful arrest. And I believe that the ultimate search of the bag that yielded the controlled substance was equally unlawful, since Mr. Smith was already in the back of the patrol car, could not reach the bag, and therefore it's not search incident to arrest under Gant, Arizona versus Gant.
This is the constitutional heart of the defense case. Arizona versus Gant limits searches incident to arrest when a suspect cannot access the area searched. Defense counsel argues the bag was out of reach, the defendant secured, and the justification expired. This argument doesn't need to win today. It needs to survive. Judge Simpson acknowledges it as a factual dispute, not a preliminary defect. That's a critical distinction. This means suppression is still alive. The defense has successfully preserved the issue for circuit court, where standards are higher and consequences more severe. Viewer engagement. Should evidence be excluded even if it proves serious crimes when police procedures are questionable?
And lastly, the lab report tells us there's 1.88 grams of a combination of methamphetamine, cocaine, and xylazine. We have charges of possession with intent to deliver less than 50 on counts 1 and 2. And while the officer testified there were other drugs, we don't have any indications of amounts. So and I would ask that this, and without something more, again, in terms of actual measurements of these other substances that the officer found, he says there was a scale. He says it looks like more than somebody would have for personal use. But without some more evidence, that is more speculation than I think it is for probable cause for bind over on possession with intent to deliver. So I've made my request that the evidence should be suppressed and all the charges should actually be dismissed.
Anything else on that?
Extremely quickly, Your Honor. Not that this is going to be outcome determinative, but the case that counsel cited, City of Troy versus Olinger, concerned whether or not an officer may enter a home without a warrant when he believes that the person inside that home may be injured in terms of that community caretaking function. I don't think that case has anything remotely relevant to the facts presented here.
It's not applicable. Factually, it's not applicable. Court, having heard the testimony in the case, the court believes that the people have indeed sustained their burden of finding the defendant over. It may be a factual question as to the amount, but certainly you can argue that in circuit court.
This is the ruling, and it's measured. Judge Simpson doesn't overreach. He repeatedly emphasizes factual disputes as the reason for bind over. That language matters. It protects the ruling from appeal and preserves fairness. Counts 1, 2, 3, and 5 move forward. The court explicitly recognizes defense arguments but deems them appropriate for trial, not dismissal. This is how preliminary exams are supposed to work. They are filters, not verdicts. Audience question, does this ruling feel fair, or does it feel like the bar for moving forward is too low?
And so as to the drugs at issue in count 1 and 2, the court would find that the people have sustained their burden. It's also to count 3, there is he's sufficiently, if the issue is that he didn't have knowledge that the bike was stolen, then certainly counsel's free to argue that in circuit court, but that creates a factual issue. He's there present on a stolen motor vehicle, and then when questioned by the officer and held by the officer, takes off, but later on it's determined that that vehicle is stolen. I think that's sufficient enough evidence regarding the count 3, the receipt and concealment of stolen property, motor vehicle. As to count 5, the resisting and obstructing. I don't even understand, quite frankly, defense's argument, because the cold-hearted reality is the officer gets there, and what negates defendant's argument more than anything is their own exhibit, defendant A, or exhibit A, which clearly lays out what the officer is doing. The officer is investigating a circumstance, and as I indicated, like with many officers, they don't know exactly what they're running into or what they have in front of them, but he's noticing certain things. He has gave him a lawful command to remain where he was and not back that vehicle up, and then he proceeded to take off. Even when he took off and the officer then says, "Stop, police," that in and of itself can constitute the offense of a resisting and obstructing after he began to run, because that was indeed, in this court's opinion.
Judge Simpson explains his reasoning clearly, especially regarding resisting and obstructing. The focus is on lawful commands and the defendant's response. Importantly, the judge references the defense's own exhibit, the body cam, as reinforcing the prosecution's case. That's a tough moment for the defense, but also a reminder. Evidence cuts both ways. This reinforces judicial credibility. The court isn't ignoring defense evidence, it's interpreting it differently. Viewer engagement. Have you ever seen evidence introduced by one side end up helping the other?
Also an additional lawful command. So for those reasons, and because anything else in dispute creates a factual dispute, which needs to be resolved by the finder of fact, court would find that people have sustained their burden and would bind the defendant over to stand trial on counts 1, 2, 4, and 5.
Acknowledge receipt of the information and waive formal reading and stand mute as to counts 1, 2, 3, and 5.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set for July 29, 2025, 1:30 before Judge Simpson.
Thank you, Your Honor.
As to his bond, I have a violation report.
Yes, Your Honor.
Well, how come he hasn't reported to community corrections after his release from custody?
He had been in custody since about January of this year. And in speaking to Mr. Smith, he was only released from the Jackson County Jail about 2 weeks ago. He had bonded out on all these cases. When he was arraigned, I believe he was told, because he was also on probation in Monroe County, that
if he goes over there and tests right now, is he going to test clean?
He should be clean, Your Honor.
Go over and test. He needs to come back. You'll need to remain here, and then they'll set his bond. The People's State of Michigan versus Cody Moore.
People.
And Alex Warren Green on behalf of Mr. Moore. You state your name, Mr. Moore.
Cody Moore.
Your Honor, today's date and time for preliminary examination. I had an opportunity to speak with Ms. McDuffie about Mr. Moore's case. We are respectfully requesting an adjournment to, I'll leave it in the court's discretion.
Why?
Your Honor, if I may, we have discussed the resolution in this case. I just need a couple of weeks to get the information that we need, and I believe I'll be able to send the knowledge to the court once I receive that in the next 3 weeks or so. For Mr. Warren.
That's my understanding, Your Honor. We did attempt to contact Mr. Moore's parole agent. We need to follow up with her. We want to track Mr. Moore's progress over the next few weeks with respect to his drug testing.
Preliminary examination will be adjourned to June 17th, 2025 at 12 p.m. Bond continued. Let's call the case, People versus Montel Gap. Two cases.
Andrew Childers appearing on behalf of the people, Your Honor.
Assistant Public Defender Ben Dennis on behalf of Mr. Gatlin, who stands to my right, and you state your name for the record, sir.
My name is Montel Gallo.
Thank you. All right. 8 times that. Oh, yes, sir.
Hey, John, before we proceed, I would like to just take accountability for what I've done. I would like to plead guilty. So
Hold up.
No,
Mr. Gatlin, Mr. Gatlin. No, hold on a second. Okay, hold on. There's a process to it, okay? And so I hear what you're saying, not discounting it, but this would not be the place to do it, to do that right now. The question would be today, given what you kind of just said, as to whether or not you want to have this preliminary examination.
I would like to hold it, and I would like the court to hear me out. That's it.
So you want to hold your preliminary examination?
Yes, I would like to hold.
Okay. Did you want to speak further with your counsel, given what you just said? And
I would not like to speak further with my counsel. I feel like my counsel
is what?
who he is.
Okay. All right. Okay, but I just want to make sure, and I'm doing this because I want to make sure things are fair for you, that you understand this isn't the point at which you would testify typically. You understand that?
Yes. Yes.
Okay, that's what I'm trying to. So here's the thing, Scott. You said something to me or said something out loud, stopped you, right?
Yes.
Then when I asked whether or not you wanted to have your preliminary examination, you then stated that you want to be heard.
Yes.
Okay. This proceeding, the preliminary examination, not saying it hasn't happened before, but this particular proceeding is not one where you would typically be testifying or saying things to the court.
I would love to if you would give me a chance.
Okay, well, let me do this, okay? Because again, I'm not disputing anything that you may want to do. I just have to make sure that you're not doing something that may jeopardize your rights, okay? So just bear with me. I got to do my job, right? Okay, all right, so I'm hearing you. I think what I'm going to do is I'm going to pass the matter. I'm going to let you just briefly talk with your attorney and maybe the chief deputy of the public defender's office so that process-wise you understand it and understand what typically will happen at this proceeding and what won't happen, or what typically happens at this proceeding and also what typically does not happen. Okay. And I think you may be asking to do something that typically does not happen. And I just want you to be clear on that. Okay.
I'm just trying to plead to all.
Stop. Hold on. I hear you. If that's what you want to do, there's a way maybe to go about doing that. Okay.
I don't think they want to help me.
Well, hold on. Stan, I hear you. Okay. I'm trying to say it in a way. Here's what I'm going to do. I'm going to pass the matter. We'll find Mr. Brown. I'm going to have you talk to Mr. Brown. All right. With the PD's office, just to make sure you're clear on everything, because I have to make sure that your rights are protected. Okay. So we're going to do it that way. We're going to do it that way. All right. That may mean you might come back up and I might be in the same boat, but I just have to make sure. Okay. Fair enough. Okay. So let's take him back.
Your Honor, real quick.
Okay.
Yeah, matter of fact.
Take him back. Council approach, please. Let's call the case of the people versus McLaughlin.
Andrew Childers appearing on behalf of the people.
We're ready. All right, although we were trying to avoid adjourning, my understanding is the circumstance which the officers involved in is a much more serious one than.
Right, and in fact, another deputy just left because they're requiring extra assistance. Just so the record's clear, that the deputy, Rob, who's involved in this case, is on the SWAT team. They are currently dispatched to some sort of barricaded gunman situation. And that situation has not cleared, so.
Did our best, we could try anyway. So preliminary examination in this matter will be continued 17th at noon.
Thank you.
All right, thank you. Continuing. Court does call the cases of the people versus Montel Gatlin.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Ben Dunaway on behalf of Mr. Gatlin, who is entering the courtroom now. Mr. Gatlin, would you state your name for the record, please?
Montel Gatlin.
Your Honor, at this time, the defense will refer Mr. Gatlin to the Forensic Center for competency. On both cases, I will email the form to the clerk of the court later today.
All right, very good.
Mr. Simpson, what's going on here?
I'm sorry.
What's going on here? In competency?
Well, they've asked for a forensic evaluation. There's not, well, just Gatlin, just hold on a minute. I can't, when it's requested by counsel, there's really not a lot I can do except to do the referral. Okay.
A forensics on what?
Likely for competency and criminal responsibility.
I'm just saying, what's their reason for trying to even do this just because I was trying to say something?
Well,
What's their reason?
no. I don't. Okay, so I'm not privy by design to all of the conversation that you have with counsel. You have conversations with counsel.
And still state what I wanted to state on record.
And I'm gonna tell you something, Mr. Gatlin. That would. I just hold on a second. I don't know that would not only be a wise decision for you to come out and start stating stuff, but would also make me a bit concerned as to whether or not you understand the nature and objects of the proceedings. That is why I stopped it where I did the first time. And you're still in, and you're still in the same spot. And so your counsel has come out, they've asked for that. I'm gonna proceed to their request because they've made the request. So set a competency hearing date for
September
9th, 2025, 9 a.m.
Mr.
Simpson, go ahead. Go ahead.
So you telling me they pushing my next court date all the way to September just because I wanted to come in here and take accountability?
No, I don't know. I don't think you should look at it that way because the two aren't necessarily connected that way. They're not trying to push your case. The problem, Mr. Gatlin, is you're trying to do things that may not be in your best interest.
It's in my best interest.
No, it is not.
This exchange with another defendant shows Judge Simpson's broader courtroom philosophy. Protecting rights sometimes means stopping defendants from hurting themselves. Competency evaluations aren't punishments. They're safeguards. When a defendant insists on self-incriminating actions, courts step in. This moment contrasts sharply with the earlier case, highlighting how different defendants require different judicial responses. It also reinforces the judge's authority and patience, even under tension. Viewer engagement. Should courts intervene more aggressively when defendants act against legal advice?
That is why that is why I stopped the proceedings when I did. It was clear to me that what you were trying to do was not part of the process, and may very well be against your interest to just
Take accountability.
it's clear you don't understand how this works. Then.
I'm being charged with some charges, and I was clearly just trying to take accountability for my charges.
And
That's
accountability can happen, but it doesn't mean that you load yourself up with everything that's there, which is what you were trying to do. And hold on, no, hold on. After, when we had Mr. Brown up there and I talked to Mr. Brown and Mr. Childers, Denowith, it's clear that there's an offer of some type.
I don't want
There's part of the problem. You're trying to, I'm done. Because you're not listening to it. You're just deciding you want to do something your way. I'm trying to explain to you why I'm doing it this way. I'm done. Bond continue.
September 5, Your
No,
Honor.
no. Nine. Don't you dare leave this building without those orders for me to sign.
Yeah, I was gonna email them to a clerk.
Yeah, you better get them today. I want to sign off on them.
I'll go type it in.
And James Fifelski on behalf of Mr. Smith, please state your name.
Stephen Smith.
All right.
Your Honor, my client has a script for the Suboxone. He was actually receiving this in custody and they gave him a script when he left. So I can present that to the court.
Does he have a medical marijuana card?
He did, Your Honor. It's my understanding that it was taken into police property or something in one of these arrests. So I would certainly advise him not to consume marijuana.
He's not to be.
He didn't have a.
I'm looking at the bond conditions. He's not supposed to be using marijuana at all.
Okay.
So
He just, as I told the court earlier, he just got out of custody after about 5.5 months. I think it was 2 weeks ago. He is doing group treatment at Catholic Charities, I believe up in Fenton, Howell. He certainly is aware of his dependence issues and treating those as best he can. I would just ask the court to continue him on bond.
we're gonna need a new order for him.
Okay.
All right.
Yeah,
All right.
I've been on probation with the Department of Corrections, and they've allowed me to smoke marijuana with my
I'm telling
medical.
you what the order reads, and what you
Yeah.
can do is you can bring that up. I'm telling you, you cannot.
I understand now.
You can bring that to
I understand.
Judge Kunke's attention if you wish to do so.
I understand.
All right.
So no marijuana unless ordered by Judge Kunke or permitted by Judge Kunke. Got that?
Yep.
All right.
Thank you very much.
I'm preparing a new order consistent with the previous order so that he shouldn't have a problem testing.
Okay.
All right.
And he's gonna, I believe, go back to community corrections right now to get on board with testing.
Thank you.
Thank you, Judge.
This courtroom session delivers a clear lesson in how the justice system actually operates, not in headlines, but in procedure. The defendant was not convicted today. Instead, the court found sufficient probable cause to move serious felony charges forward. Key issues remain unresolved: the legality of the initial detention, the scope of the search incident to arrest, and whether intent to deliver can be proven beyond inference. Judge Simpson acknowledged these as factual disputes, exactly where juries belong. The broader implication is accountability on both sides. Police actions will be scrutinized. Prosecutors must tighten proof. Defense counsel preserved critical constitutional challenges. This case now moves into circuit court, where the stakes rise and the margin for error shrinks. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.